This past weekend, New York State passed one of the largest housing bills that we've seen since the rent laws of 2019. One of the biggest components of that bill was good cause eviction. We are here with a special guest to share everything we know so far about this impactful new legislation. My name is DJ Johnston. I am an executive vice president at Matthews. I'm here with my partner, Brock Emmetsberger. And here are our 5 points.
Thanks, DJ, and welcome to the 5 points, where we're hoping not to get through this quickly. Always the spirit of this call is not to hold anyone for too long, just get through the information. And we're very fortunate today that we have Alexander Fotopoulos of K&F PLLC, their law firm that specializes in landlord-tenant matters here in New York City. I happen to think that Alex is one of the best people in town that we can get for this call to cover these new rent laws. When I set up the call, it was called proposed laws. Now that it's today, past the weekend, they're now enacted. So without further ado, let's go through the 5 points. The points that we're going to be going through today are discussing perpetuity, how with the tenants that are in place now, how they'll be offered renewals moving forward. So Alex will discuss that. Increases to those leases that get renewals, or proposed increases for those renewed leases where tenants can then accept or move on from those proposed increases. Any exemptions to this rule, and units and buildings that will not be part of good cause eviction. Enforceability, if tenants bring up a dispute, how this will be enforced, and outcomes that we could see moving forward. So, Alex, starting with you, if 30 seconds on yourself, and then we'll talk about perpetuity.
Hey, Brock, thank you for having me. DJ, you as well. My name is Alex Fotopoulos. I am an attorney practicing in the area of rent regulation and landlord-tenant. I've been doing it for about 10 years, representing almost exclusively landlords. A lot of diligence, overcharge complaints, rent roll development counseling. So again, thank you both for having me, and it's a pleasure to be here. Brock, I'll talk a little bit about each of the points I think that you brought up, and I think first, I'll just give a very broad summary of what good cause eviction is. So good cause eviction limits on fair market units, or on most fair market units, the rental increases that an owner can take on renewal, and also protects tenants from not being renewed by their landlords. Their lease is not being renewed by their landlord.
Yeah, we'll talk. Yeah, I guess for start, let's talk about, for the first point, renewals and perpetuity. That moving forward, free market tenants and anyone out there signing a lease today will have rights for renewal and perpetuity of those leases. So yeah, if you could touch on that briefly.
That's right. So landlords will not be able to arbitrarily decide that they no longer want their fair market tenants in the apartment. They are under a requirement to renew the lease, except under certain circumstances. I'll give you the 5 or 6 main reasons not to renew a fair market tenant's lease. So a tenant's failure to pay rent, a landlord's desire to demolish the apartment, a tenant's nuisance conduct, a tenant's breach of a substantial obligation of the lease, or where the landlord seeks to demolish the apartment, seem to be the most pertinent, I think, bases for refusing to terminate a lease.
Now, Alex, is that just demolishing the unit in the interior, or is there a broader one for sub-rehab of the building, of substantial rehabilitation of the building?
So that's a really good question, Brock, and that remains an open question. I think what's interesting is that the legislation says a demolition of the housing accommodation. So the housing accommodation is the apartment. I don't know what demolition means. Demolition could mean that the interior of the unit is demolished. Demolition could mean that the apartment doesn't come back onto the rental market as the existing unit. That's going to be something that that is something that the legislation is not clear on, and it's going to be for the courts to decide. You know, how broad that definition or how narrow that definition is.
I think it's important too, as we move through our points here, to know that this was just enacted on Sunday. So we're covering with you all the information we know so far, which thankfully Alex knows a lot. But moving forward, there's certainly more things that will be coming up, more items that will need to be defined, and we'll certainly have follow-up segments on those as well.
Actually, Brock, before we move on from this section, there's one other I think exception to or one other basis of good cause eviction that a landlord might be able to avail himself of. So there's this very broad sort of catch-all provision that says where a tenant refuses to agree to reasonable changes to a lease renewal. And what that means, in addition to the other bases that I just gave you, is going to be, I think, very hotly litigated in the housing court. One of the unfortunate results of this law is that all of this is probably going to be litigated in housing court, which is going to make for a very slow and arduous process for landlords. And the housing court, as you both already know, is overwhelmed. So I think that one of the effects of this law is to bring back buyouts. I think you're going to see, just practically speaking, I think you'll probably see buyouts of fair market tenants, certainly not six-figure buyouts like you were getting in rent stabilized units prior to 2019, but it wouldn't surprise me if landlords approached below market tenants for buyouts.
That's interesting, Alex, because then tenants have somewhat of a leasehold on their units, right? So they have some control and potentially some ownership of those units because of this, right? Similar to what we saw in the rent stabilized units. And we're talking about perpetuity, but it's not. Is this set to go on forever? Are there expirations, on this legislation?
So there is a sunset provision. The law is set to expire, I believe, in June of 2034. Whether or not it's renewed remains to be seen, but it has, about a 10-year shelf life, as it currently exists.
All right, so everybody set their calendars.
Yep, put a reminder on. That's right.
All right. So
hey Siri, set a reminder for 10 years from now.
So with perpetuity, one of the biggest changes now is, of course, for owners who want to gain vacant possession of their property, how that's now going to have this in place. So it's not as easy historically when a tenant signs a lease, it's an agreement between the landlord and the tenant, and when that lease expires, landlord gets possession of the unit back, they get vacant possession. That's no longer automatically the case. Now, when these leases are signed, let's go to point number 2, increases. What type of increases should tenants expect moving forward once they sign a new good cause eviction lease, annual lease?
So the law provides that there's a presumption of reasonableness where the increase in rent is the lesser of 5% plus the change in the consumer price index, CPI, or 10%. So putting that into numbers today, you're looking at about an 8.5% increase on renewals for going forward. The DHCR actually it appears is going to be the agency tasked with running or administering some of this. And every August, the DHCR is going to tell us what the CPI is. It's going to publish the CPI for the year based on certain records published by the federal government. And if we go by last August's change in CPI, that's 3.5%. So 5 plus 3.5 is 8.5.
Got it. Now, DHCR obviously has a calculation that will dictate, but do landlords have to make any sort of registrations with the DHCR, or this is truly just a response to a tenant complaint? There's no proactive measure that landlords need to take.
There's no registration requirement set forth in the law. There is a notice or rider requirement set forth in the law. So I believe that the rider requirement goes into effect in August of 24. And that rider will inform the tenant whether or not the apartment is subject to good cause eviction. If it is, there'll be a place that you check for yes. If it isn't, the landlord will have to make an affirmative statement as to why. Now, what's interesting in all of this is that there are circumstances where an increase of more than the 8.5% can be reasonable in the event of a challenge. So some of those circumstances or some of those bases for an increase of more than the 8.5% that the courts are instructed to look at are increases in the landlord's costs, particularly as it relates to property taxes, where the landlord performs a significant repair, either in the building or in the apartment, that might also rebut the presumption of unreasonableness where the increase is more than 8.5 or 10%.
And would that follow standard MCI and IAI calculations, or is this something else we're waiting for too, as far as guidance?
That is going to be left up to the courts. I do not believe that the courts should follow the IAI calculations because that's an entirely different regime of regulation. Although the courts might look at that to be instructive. It's sort of exciting to a certain extent, Brock. As a lawyer, you're going to make up a whole new area of law is going to be created as to what is reasonable, what is unreasonable. I would venture to say that where a landlord completely guts an apartment or performs significant renovations to a building, let's say puts in a new elevator, puts in a new roof, that they will see, I don't want to use the word generous, but they will be able to justify increases of more than 10%. And if I can just add here, and you guys are the market experts more than I am on this point, most apartments that are renting at or close to market aren't going to see an increase on renewal of more than 10%. I mean, that's unusual. That's increases of that size you saw right after COVID because there were huge discounts being offered. Generally speaking, I don't think market tenants get 8.5, 10% increases year over year.
Yeah, that didn't particularly frighten me, particularly at market levels, right? But there's obviously units that need repairs that can see increases in rents. So I think a good takeaway for building owners is that even if you're doing minor repairs, keep evidence, right? Keep bills, keep photos. Not that this is a sub rehab, but you almost want to just make sure that you're tracking all the improvements made, because if you need to justify an increase above 10%, you have the paperwork to back it up or the proof to back it up.
That's the point that I've made to a lot of clients over the last day or two. You're almost back to the days of IAIs and documentation, individual apartment improvements, and the corollary documentation requirements. You want to keep invoices that are specific to apartments. You want to keep canceled checks because all of this may come up in the future. And if work is being done, you might as well throw it into a folder while you still can.
And Alex, I just want to clarify too. So for this year, hypothetically, it would be 8.5%, the 3.5% CPI plus the 5%. And at no point can it go over 10%. Is that correct? So it's the lesser of that. It just maxes out and the ceiling's 10%. That's
correct. So if 5% plus the change in CPI is more than 10%, 10% is the ceiling. Absent, that's the ceiling for the reasonable increase. Correct.
Okay.
God help us if we get more inflation. So let's almost hope that it stays at 8.5%.
So, but in the event, is there any floor? So in the event we go negative, is there a floor, or is it, if we see a dip in the economy, can it be less than 5%?
So 5%, just the plain language of the statute, right? 5% plus the change in CPI can be interpreted, I mean, I suppose if there was negative inflation, you may get into a situation where you could have less than 5% increases. I doubt that that's the intent of the bill, but that also remains to be seen. Also, I mean, I think we're a long way from negative inflation, so we'll see where we go with that. But I don't think that that's something that's going to be litigated anytime soon, given where we are.
Well, thank you so much for covering the point regarding increases. Let's talk exemptions. Let's talk about what buildings and what units may not be subject to good cause eviction moving forward.
Yep. So the easiest apartments that are not subject to good cause eviction are apartments that are already subject to rent stabilization, or other regulatory agreements that set a minimum kind of rent. Buildings that are owned by small landlords are also exempt. So a small landlord is a landlord that owns less than 10 units altogether, or where the landlord occupies a building with less than 10 units. Now, I know what the next question is going to be, or I can anticipate what happens when an entity owns a building. If any individual that owns a beneficial interest in the LLC owns or has a beneficial interest in more than 10 apartments in New York State, the small landlord exemption will not apply. So, and the landlord would have to make an affirmative statement as to what he or she owns in terms of number of apartments, or what he or she has a beneficial interest in. So I believe the legislature has really inhibited an owner's ability to be cute, if you will, on that point. So that's the second exemption. Apartments occupied by a superintendent or employee of the owner are exempt. Condos and co-ops are exempt. This next one is interesting. Buildings where a temporary certificate of occupancy or a final certificate of occupancy was issued after January 1 of 2009 are exempt for 30 years. So 421A buildings, where this certificate of occupancy was issued after 2009, would be exempt at the expiration of the benefit period, if that benefit period is less than 30 years, if it's less than a 30-year abatement. What is really interesting about this particular exemption is that the language doesn't say that the first temporary certificate or the first certificate of occupancy must have been issued after January 1, 2009. It just says that a temporary or permanent certificate was issued after January 1 of 2009. I think that the intent of the law here was really to cover new construction, but the language was, in my view, a little bit broader than that. So I think that will be a litigated issue as well. And then the last, I think, really pertinent exception are apartments that are rented where the monthly rent exceeds 245% of the fair market rent established by the United States Department of Housing and Urban Development. Those are really, really, really high rent units. I don't know how many of them exist in, walk-ups or small elevator buildings.
It's about 50, comes out to about 5,800, right? Is that the number, the monthly number?
It depends. So it's based on zip code and size of the apartment. My calculations were actually a little bit higher than that, Brock, but I guess I would want to see the table that you're using. I think you're almost over. I think you're over $7,000 at a studio, for Manhattan. But
Wow.
I think that it's a very hard exemption to fulfill.
Great. And then just to clarify earlier, it's buildings 10 units or under, or portfolios 10 units and under, and it has to be owner occupied? Or is
No.
it just that if it's 10 units or under, it's exempt?
Correct. Or
Great.
if the
That's-
owner lives, I mean, I suppose the
Or
other
if it's owner
exemption.
occupied.
Correct.
Got it.
Correct.
Great. Thank you.
I'm sorry, I need further clarification there. So buildings under 10 units are exempt?
No. So
Right.
it appears, and again, this is all going to be litigated. If an individual owns 20 units, but lives in one of the buildings that is 10
Right.
units or less, it looks like that building where there are 10 units or less may, I stress, may be exempt from good cause. You're muted, DJ.
Sorry. What if they own units out of state? Right, so they own a big portfolio out of state, they own one family building in New York.
This seems to capture only units owned in New York State, not outside of New York State. So the small landlord exemption would appear to apply in that circumstance.
Now, I don't think we have an answer to this, but a lot of my clients have been asking me if they went through an alt one, let's say they had a 3-unit building, they converted it to an 8, right? So they got a new C of O. Do you think that qualifies as a new building, or does that be a new building permit? I guess these are the questions that will, get answered over the next few weeks.
I think the intent was to only include new constructions, right? New buildings, but that's not what the actual text of the legislation says. So that's going to be a very interesting point. What might even make that more interesting, DJ, is if what the use of the building was previously. So if you converted a commercial building to residential, that might be more favorably looked upon than converting a 3-family to an 8-family post 2009. But these are all open questions. This is all going to be litigation.
That was great summary right there. Really appreciate it, Alex. Let's from there and that cover, my apologies, that cover most of the exemptions, or was there anything else that I left off?
I think those are the most pertinent exemptions.
Most pertinent ones.
Looking at.
Great. And let's talk enforceability. Who do we see enforcing these laws? How is that going to work? As you mentioned already, it's gonna be a new rider that's attached to all leases moving forward. You'll have a good cause eviction rider that's attached to the lease as a tenant. How do you see these laws being enforced? You already mentioned that likely this isn't going to be something that will need to be registered with the DHCR, but if you could walk us through that.
This is also a very good question. So I don't think that landlords can just be sending non-renewal notices to tenants anymore. That the days of just sending non-renewal notices are probably over, or are over. What'll be more interesting is when you send renewal leases with increases of more than the 8.5%. And a landlord says, well, I'm doing this because of X, Y, and Z reason. It'll be up to the tenant, I guess, in that circumstance, to challenge the landlord. And the place where I think that's most likely to happen is housing court. A tenant would say, no, I'm not leaving, I'm protected. And then a landlord would go to court and say, either you're not protected for this reason, or the rent increase is reasonable. Again, the issue with this is that it's going to be a long and arduous process. And I don't think that the legislature or the housing court is incentivized to make it faster or more expeditious for landlords. So I'm also not sure, and it remains to be seen, if DHCR might have some authority or jurisdiction here. I don't know if there will be good cause eviction applications or complaints that might be able to be filed with DHCR. I doubt it, but it's possible. And I should add that any waiver of good cause eviction by any tenant in a lease is void as a matter of law, just as any waiver of rent stabilization would also be. Brock, you're muted. There you go.
Amateur hour over here on my side. Thank you, DJ. Any questions for Alex regarding enforceability?
No, Alex, I guess, we're not the first state to have a good cause, right? And I don't know if we've had a chance to study other kind of other city systems like, San Francisco and how they address enforceability. Like, is there a guideline here? Is there precedent in other states that New York seems to be following?
So there are two states that have, well, actually there might be three, but there are two states that have had some version of this for some time. It's California, as you just suggested, and also New Jersey. New Jersey has an unconscionability standard, which is a little bit different than what we have here. If my memory serves me correctly, and I looked at this years ago, the New Jersey bill says that a rental increase can't be unconscionable. It doesn't set forth a specific numerical value as to what unconscionability is. So I suspect that we will be looking to California and New York and New Jersey. And I suspect that judges might also be looking to see what other states do here. But it does seem that there is a vacancy reset, meaning that at vacancy, you can reset the rent to market, but a landlord should keep documentation of all repairs done to a unit. So if you get an apartment back from a market tenant and you do a value add, you should keep, or a landlord should keep, all his or her records, because a tenant may be able to say that, a rental increase without a significant repair is unreasonable.
Yeah, that's a very important point that you brought up, that it does look like there'll be a market first rent provision, correct? That once a tenant vacates, it'll be the next lease can be at market first rent. So that, that certainly seems very, very important, that there's not going to be any guidelines or provisions on increases after receiving vacant possession.
That's right, but with the caveat that if you do increase the rent significantly, you definitely want to show why that is. So I would certainly keep all records pertaining to why that increase, was taken.
So there is in the legislation saying that someone's paying $5,000 a month, their lease expires, they decide not to renew, they move out, that there is potential that the housing court or DHCR or whoever's enforcing this is going to come back and ask for documents showing why the next rent is at $7,500 a month for one reason or another. There may need to be some documentation provided.
There's a provision in here which, again, I don't want to give too much of an interpretation of, because I think it's still very unclear, that says that if a tenant refuses to pay, if you refuse to renew a tenant's lease based on the non-payment of rent, and they raise a defense that the rent is unreasonable, the tenant could potentially look at all the rents that were charged after the enactment of this statute, in determining whether the rent is reasonable.
And this is for a new tenant coming in.
This is for any tenant.
Yeah, got it.
So, but I will say that provision, I think, will also be very hotly litigated. And I'll also say that, look, most of the time you're not raising the rent 30 or 40% on a fair market unit unless you're doing a significant renovation, or unless your rent was extremely depressed because of some event. Maybe there was construction in the building, maybe because of COVID your rents haven't recovered. I don't think that landlords are generally raising rents significantly without doing some work or without some underlying reason. And what the law at least seems to implicate is that there's going to be an unlimited look back from 2024 forward on the rental increases. That is going to be a very interesting question. And I'm not sure that the tenants are going to get free rein there. I think the courts may push back a little on that. I mean, there's a 6-year statute of limitations on overcharges. Is the legislature really saying that there could be a longer look back on fair market apartments? That sounds bizarre, to me.
Right. And, and for our last, our last point here, we're talking about outcomes moving forward. So this is going to be a bit of a roundtable where each of us will just spend a minute talking about outcomes that we see moving forward, 2 or 3 different outcomes that'll be produced by good cause eviction. The 2 things I want to touch on real quickly. The biggest concern from my end is vacant possession. I find some irony that in this bill, that a big part of the bill is to create more affordable housing throughout New York City and create more affordability for tenants throughout the city. Yet, of course, what this will do is create less turnover of free market apartments, where in Manhattan below 96th Street, that vacancy rate is already below 1.5%. Now you have even less there. That's going to push up rents, of course, for any units that are exempted out of the program. These will be ones that turn over more, and you have less of those units. So that's going to push, that will put a squeeze on open supply, and ironically push rents up even higher for those units where it's where good cause eviction is not in place. Secondly, there's not going to be for as far as available development sites. If developers are, if there's going to be barriers in place and challenges to getting vacant possession of free market buildings, that's going to limit opportunities for further development, right? If there is not a straight demolition provision for the building, which we're still trying to get more information on, that effectively could help. That could certainly hinder the city's efforts in producing more affordable housing. So that, that I think there's definitely some irony there. If we put in these new provisions that we'll talk about to increase the bulk of affordable housing, but yet we can't get vacant possession of these buildings to assemble affordable housing sites. That certainly could be an issue. And the last outcome that I want to touch on is the regional banks. We've certainly seen the negative effects of the 2019 rent laws and what that did to Signature Bank, and what's happening with New York Community Bank right now. And of course, there's other banks that are seeing distress. Valley National with their portfolio of rent regulated buildings. What happens here, where you had loans that, of course, were issued to owners of free market buildings that now have these provisions in place that will reel in rents, that will have restrictions capping additional development. These are all outcomes that we have to keep an eye on.
Yeah, I would just add to that. I don't know what the city and state has against boutique owners. I just feel like it's regulation over regulation over regulation. I read somewhere that if you had to post every sign that the city requires in your building, there'd be like 38 signs sitting in every lobby of every residential building in New York. And I think what it's doing is just deterring, private capital and boutique capital from investing in these, these burgeoning neighborhoods. And it's just been a real shame. And even if you have, you say, well, they've put provisions in place, right? 10 units or under. Well, a lot of people raise money, right? They have an LP, a rich uncle who owns a lot of units, and he's trying to, he or she's trying to build a business model, investing in real estate in New York City. Yes, somewhere in the capital stack, there's going to be someone who owns a lot of real estate because, that's where the equity comes from. So I'm just disappointed that, I feel like the smaller owners have just been left with the bag, and it's been really frustrating. It's been frustrating for a lot of my clients. And again, I don't think it services the needs that they set out to service. So, hopefully things change over time. I'm happy that there's a framework. I'm happy that we know what we're dealing with now, and that we can kind of strategize around the laws that we're given. I'm grateful for people like Alex who really know what they're doing. I would say that if there's any time to build a team around managing a building, you should have a really good manager. You should have a really good expediter. You should have a really good DHCR and tenant landlord attorney. And good brokers too, throw us in the mix. Why don't you? But
Don't
again,
forget the brokers, DJ.
Don't forget the brokers. Build a team.
Selfless brokers.
Yeah. Build your team. I think, and I want to thank you, Alex. I don't know if you have anything else to add, but I just really want to thank you for your insight and always providing your insight, always being accessible. I know that translates to your clients and new clients as well. So thank you for all of this. Really appreciate it.
Thank you, DJ and Brock. I'll just end with, I agree with everything that you both just said, but I'm somewhat more optimistic. I've looked at tens of thousands of apartments over the last 10 years of doing this. Most tenants in fair market units are transient in the sense that they don't stay for more than 3 years, 4 years. I read a statistic someplace that I think below 14th Street, the average life of a tenancy, or maybe it wasn't, maybe I didn't read, maybe somebody told me, was like 1.8 years, which is really not a long time. So you're going to get natural turnover in most of the buildings that we work on, right? Most of the market units that we work on. And I think that, yes, this will probably certainly have a downward pressure on buildings that have below market rents or where the apartments are big and tenants don't want to leave. But for apartment buildings that are occupied by young professionals, meaning between 23 and 35 years old, I'm not sure that this is going to have a tremendous effect on a renovator's ability to renovate into a value add. I think you're going to see turnover. I don't think that you're going to see a lot of fighting by fair market tenants to stay in apartments because the rents for the most part are over $3,000, $3,500. So I'm somewhat more optimistic. This is certainly not good for ownership and for developers. And I think my last point is this about building a team. I think this is a complete failure on the part of real estate in New York to have a voice in Albany. The only lobby in Albany that really had a voice was developers. There's been a complete abdication on the part of smaller owners. And when I say smaller owners, I mean guys that own up to 5,000 units and walk-ups or relatively small buildings, sub 50 unit buildings, of any sort of political engagement. And I think that needs to change on our part. I think it needs to be grassroots, and it needs to involve the managers, the lawyers, the brokers, the contractors, the expediters, because it's more than just the rich landlords that really live off this. At the end of the day, we want good housing, and the only people that are going to be able to provide good housing are people that are willing to invest. So I think that's on us, and we really need to think about how we can develop a voice going forward.
Well, thank you, Alex. Welcome your thoughts. We certainly welcome your optimism. I'll hop on that train with you. So thank you again, much appreciated. And moving forward, we're certainly looking forward to having you on as a guest again. We'll be checking in about any changes to Good Cause Eviction. And thanks again for joining us. Much appreciated.
Thank you.
Thanks, Alex. You're the best.
Bye, guys.